Okay, we'll call to order the regular meeting of the East Bethel City Council for July 22nd, 2024. Please join us in saying the Pledge of Allegiance.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Make a motion to adopt tonight's agenda.
Second.
Motion made and seconded. All in favor say aye.
Aye.
Opposed? None heard. Item 4, presentations and public hearings. First, we'll hear from, is it Sergeant Scott Wickland of the Anoka County Sheriff's Office. Thanks for joining us.
Thank you for having me. Good evening, Mayor, council members. My name is Scott Wickland. I'm a sergeant in our patrol division. June had a total of 422 calls for service, which was down from the 449 calls we had and responded to in May. Deputies handled 6 assaults, 4 thefts, and 2 damage to property calls. Deputies made a total of 30 arrests for miscellaneous offenses, made 186 traffic stops, which resulted in the issuance of 49 traffic citations, which was our highest monthly total for the year. Some notable calls our deputies handled this or past month included a third-degree DWI on June 1st at 8 p.m. Deputy Aldine was one of our East Bethel deputies that stopped a vehicle at 200 block of Polk Street because the RO had an active Stearns County misdemeanor warrant. Deputy Aldine contacted the driver, who was identified as a male with a warrant, and while speaking with the male, Deputy Aldine noticed several signs of a chemical impairment and believed the male may be possibly intoxicated. The deputy had the male perform SFSTs, which he failed. He was ultimately arrested for the driver for DWI and transported him to the ACSO, where he submitted to a evidentiary test, which resulted in a reported value of a .22 BAC. The driver was transported to jail and booked for third-degree DWI and his outstanding warrant. Deputy Sorensen had a driver under cancellation IPS on June 2nd at 1:44 p.m. Deputy Sorensen stopped a vehicle for speeding through the 2900 block of Durant Street. Deputy Sorensen's radar showed the vehicle traveling at 75 miles an hour in the 55 mile an hour zone. He contacted the driver, who said he didn't have a license and was in the process of getting his back. Deputy Sorensen ran the driver's name through NCIC, which showed he was canceled. The driver allowed to switch spots with the passengers or released from the scene. A formal complaint was drafted charging the driver with driving after cancellation. Deputy Barrett made an HRO violation arrest on June 4th at 4 p.m. Deputies were dispatched to an HRO violation at the address in the 21700 block of Zumbrota Street Northeast. The RP stated the male who they had an HRO against arrived at the address and knocked on the front door before leaving. There had been no direct contact between anyone. Deputies reviewed the order and determined the male in question was prohibited from being within a mile of the residence. Deputies later located a witness who reported the male was driving near the house, presumably after he had knocked on the front door. The male was located, or not located, so deputies put a probable cause warrant out for gross misdemeanor HRO violation. Finally, Deputy Borgeson had a fleeing in a motor vehicle on June 29th at around 8 p.m. Deputy Borgeson attempted to stop a vehicle in the 19700 block of East Bethel Boulevard as the owner showed a revoked driver's license. As Deputy Borgeson activated his overhead emergency lights and siren, the vehicle failed to yield and abruptly pulled into an address in the 19800 block of East Bethel Boulevard. As soon as he turned to the driveway at this address, the truck accelerated away down a dirt road in the property. At the end of the trail, the vehicle stopped next to a camper. The male got out and began shouting at Deputy Borgeson, threatening him while walking toward the camper next to the vehicle. Fearing for what the male may have access to inside the trailer, Deputy Borgeson deployed his taser, which was successful in bringing the male to the ground. The male continued to resist, but deputies were eventually successful in placing the male in the handcuffs. The male was evaluated by fire and Alina and transported to the jail for fleeing in a motor vehicle, gross misdemeanor obstruction, and misdemeanor driving after revocation. Thankfully, no injuries were reported. We are about halfway done with the summer already, and thankfully our motor vehicle crashes last month were down significantly from the month of May. So please continue to use good judgment on our roads and waterways and call 911 if you see anything suspicious. Thank you for allowing me here to give a quick update.
Thank you for being here and giving us one. You guys have any questions? Sergeant Wicklund?
Yeah, how long are you guys gonna be pretty lenient on the fireworks?
And the fireworks, we're done being lenient.
Okay,
So over 4th of July, there are so many calls for service.
Right.
Then once 4th of July weekend ended, we put it out to our people that fireworks complaints were attended to. So after the 4th of July was over, our people were going out to the fireworks complaints.
a lot of, people blowing out that tannerite,
What's that? The tannerite?
tannerite,
I do not know. I
Yeah.
know there was a lot of explosions everywhere.
especially around Coon Lake.
There's a lot. But we will have our guys responding to the fireworks call from now.
But yet that's legal,
Tannerite?
am I right?
The substance itself, but not the noise it makes necessarily.
It rattles windows.
Mm-hmm. It sure does.
All right.
Any other questions, comments? Thank you, Sergeant Wicklund.
All right, thank you, gentlemen. Have a
Appreciate
good
you
night.
filling
Thank
in
you.
for
Coming. Yep.
Lieutenant Peters. Next on the agenda is Chief Rod Sanow, of the East Bethel Fire Department.
Good evening, Mayor and Council.
Evening.
For our June update, we responded to 83 calls for service. We responded to 55 medicals, 7 accidents, 14 other calls, which include lift assist and that, and 2 alarms. As of right now, we're at 557 calls for these calls for service this year, compared to 529 from last year. We were behind these numbers until the last 14 days, where we received 43 calls for service. And that I would like to thank CenterPoint Energy for a $2,200 grant they gave the fire department. This is a 50-50 matching grant for the purchase of 2 AEDs. In total, the units cost $4,400. These have been bought and will be placed into service this week. The old ones that we're replacing with, because we were replacing these with our first out trucks for stations 1 and 3. And then we're going to take these old units and we're going to move them to 2 of our officers that do respond directly to the scene once in a while. So they'll be carrying AEDs at the time too. So they can use them. They'll use them until we can no longer get batteries for them. And that most of these units are at least 15 years old.
Really?
That we're replacing.
Wow.
So, like I said, that's why we went with the matching grant. You know, we put in for it and got it. That in the month of July, well, on July 4th, we did have a house fire. We're on the 2400 block of Quincy. That cause of the fire is still being investigated, and we had our mutual aid partners there from the surrounding cities. I think we did have like 7 departments there in that. Also, as a reminder, Night to Unite is August 6th. You have until July 26th to register with the county for a party. They will then get us a list. We will then look at this list, divide it up, and send trucks to every party. And the firefighters will stay there as long as possible, depending on the amount of parties we need to go to. I do believe down on Coon Lake Beach, we do have a truck that spends all night there. And then the rest of the city is divided up by our 2 stations up on this side and that. So, like I said, you have until July 26th to contact the county and that get registered, and they also do send deputies out at the same time.
Yeah.
So,
Thank you.
with that, I'll take any questions.
I just have one question. I went and took a look at the house on Quincy.
Yep.
Sorry, I'm not speaking directly in the mic. And I was surprised how it seemed to run across the top of the house. Is that normal, or is it the way it was? Was it older?
That is normal.
That is normal.
The fire we believe started over in the garage.
In the garage?
And by the time We were calling, got there, it was spreading, got up into the attic and started spreading through.
So it
the house.
must have been an open attic all the way over?
Possibility,
Yeah,
I couldn't
okay.
tell you.
Yeah, okay.
You think it
Just
was
curious.
fireworks?
I don't know.
Don't
It's
know.
under being investigated.
Yeah.
And that-
Hmm. Well, thank you for updating us on that.
Okay. Any other questions? Otherwise, I gotta get going on this call. Okay,
Yep,
thank you
got
guys.
training
Thanks,
to
Chief.
do, huh? Training night?
Night to you, night, August 6th.
Yeah, okay.
Okay, thanks.
Correct me if I'm wrong, I don't have it in front of me right now, but I think the next thing on our agenda is the public forum, right?
That's correct, Mayor, and so far, no one has signed up.
Nothing up there? Okay, and that, there it is. Yeah, I find it eventually. In that case, we'll just go under the consent agenda.
We'll make a motion to approve the consent agenda.
So-
Motion's made and seconded. Discussion?
1 second here. 19. There was one on the minutes, I want to double check here.
Mayor, council members, I believe that the minutes need to be pulled so that there can be an amendment to them to indicate that I wasn't present, but that Attorney Christina Benson was the attorney present during that particular meeting. So I know that change to the minutes needs to be made.
Okay, I'll pull item B then.
Okay, and I'm pulling item A. Anybody else? Okay, on item A, which is the approved bill list, I just had a couple questions. One was, is the line item EDA professional service fees, ECM publishers, $11,284 and change. And I just wondered what that was for. And is ECM publishers the same people as the Anoka County Herald, Union Herald? Yeah. What does that account for? Or what is it for, I should say? Guys want to get back to with me?
I can speak on behalf of the Planning Commission. So when we publish public hearing notices, we send them to the newspaper for publication. We also collect a publication fee through escrow for anything that has to go out for a public hearing at the Planning Commission level.
Could
and
you,
then
could you
reimburse that.
reiterate that you collect?
Yeah, we collect an escrow for applications that require land use. And then we recoup the cost of the publication for the public hearings on land use issues from the escrow accounts that are associated with the applications. So you're probably seeing, my assumption, I don't have it in front of me, you're probably seeing where we pay out to ECM, but you're not seeing the-
$11,200 worth of publishing stuff? Public notices?
Mr. Mayor, I'm just gonna find the actual invoice here.
Yeah. That's what surprised me, was the volume of it, the size. That's,
11,284 for Civic Plus.
yeah, yeah.
Okay, that's for the website services.
Oh, so they provide our website
It's
services
not-
too?
Right, no, it's not ECM Publishers. ECM Publishers, I was confused, that is 380, $375.10.
Oh, it's Civic, okay, my mistake.
Yeah,
then I
legal
looked at the wrong one.
notices,
Got my
variance notices, candidate filing notices. The Civics Plus is our website, one-time charge that we,
That's a one-time.
one time, yeah.
Oh,
And in that fee, we get an update, which Carrie is anxious to get on, but we'll wait till after the elections.
okay.
So,
All right, well, that's, thanks for the answer. In that case, I make a motion that we approve item A, the
So-
approved bills list.
Second.
Made and seconded, all in favor say aye.
Aye.
Opposed, none heard. And Brian, you pulled B?
Yes, to insert the name Christina Benson.
Correct. And that's-
Christina?
It's Christina, Christina, Benson, Benson.
Okay,
To
thank you.
be the city attorney of record for that meeting, and I believe there was a couple of spots
Yeah,
where that name was to be inserted.
okay, so those changes to the minutes to correct them, or to complete them? So with that,
I'll make a motion to approve the minutes that are on the consent agenda.
I'll second.
motion made and seconded, in favor say aye.
Aye.
Opposed, none heard. And we have a motion made and seconded to approve the remains of the consent agenda, which is the third item, which is the grant that I believe Rod was referring to. So, all in favor of doing so, say aye.
Aye.
Opposed, none heard. Okay, new business, nothing, department reports, community development. Mr. Berg, you're up. I got 2 variance issues.
Thank you, Mr. Mayor. First item would be a variance request from Cedarwood Estates, Continental Communities, for a setback and lot standards for placement of manufactured homes on sites 17 and 125 at the property located at 18164 Highway 65 Northeast. On June 10th, 2024, a variance request was presented to the City Council for placement of manufactured home on lots 17 and 125 in the Cedarwood Estates Manufactured Home Park. At the conclusion of the presentation and discussion by the City Council, there was a request for additional information regarding the sewage treatment plant and all permits that had been issued to the park since November of 2021. City staff reached out to the MPCA and provided you with an audit report from February 17th of 2022. Staff also received an October 2017 facility evaluation report by Bolton and Menk. That was a requirement of, I believe, transfer of ownership or a requirement from the MPCA. I provided you a summary of the manufactured home placements since November 2021. If I were to provide you all of the application and associated materials, the file would be too large to transfer, but I did do a summary. I also believe I provided Councilman Smith a copy of all of the permits at his request. As well as while going through the permits, I discovered an internal memo between the East Bethel Community Development Director at the time and the building official or building inspector for residential building here in East Bethel. The proposed placements of the manufactured homes on lot 17 and lot 125 do not meet the criteria set forth to allow for the proposed structures to be placed, so variances would be required. The consideration of a variance requires the consideration of a 3-factor practical difficulties test. The first factor is a test of reasonableness, which means that the landowner would likely use the property in a practical way but cannot do so under the rules of the ordinance. This does not mean that the land cannot be put to any reasonable use whatsoever without the variance. In this case, the placement of a new manufactured home on a lot in an existing manufactured home park is reasonable. Placement of a manufactured home on a non-conforming lot with dimensions larger than any previous home is not reasonable. The expansion of a nonconformity is prohibited by East Bethel City Ordinance Section 5 and Minnesota State Statute 462.357 Sub 1E. Placement of a manufactured home within 30 feet of another manufactured home may not be reasonable. The second factor is that the landowner's problem is due to circumstances unique to the property and not caused by the landowner. This uniqueness generally relates to physical characteristics of the particular piece of property, that is, to the land, and not the personal characteristics or preferences of the landowner. In this case, Continental Communities purchased the property in its existing form and design. Due to the lack of a conditional use permit and non-conforming status of the property, the existing lot dimensions in Cedarwood Estates cannot be expanded to accommodate placements of manufactured homes with the existing setbacks. Section 38-44 of the East Bethel Code, under existing manufactured home parks, contain provisions that allow other variances may be approved by the City Council if strict compliance with said provisions of this article would be an undue hardship to the park owner. The third factor is that the variance would not alter the essential character of the neighborhood. This is used to consider whether the resulting structure would be out of scale, out of place, or otherwise inconsistent with the surroundings. In this case, there are 150 plus manufactured homes in the park, which all would not meet Section 38-25 lot standards. The encroachment and setbacks vary on each lot as a result of inconsistent lot dimensions, and a variety of manufactured home dimensions have been placed on lots throughout the history of this park. The Planning Commission on May 28, 2024 held a public hearing, and aside from a representative of Continental Communities, there was no other public comment. After a review of the application material and hearing from the applicant, the Planning Commission, after a lengthy discussion, by a 7-0 vote, recommended denial to the City Council to the variance request to reduce the lot standards and setback distances to allow the existing placement of manufactured homes on lot 17 and 125. One item of concern was raised by the Planning Commission was risk associated with fire. The National Fire Protection Association standards for safety for manufactured home installs, sites, and communities states that fire separation distances shall comply with jurisdictions' adapted building codes, local rules, and regulations. The City Council should review the additional information requested, consider the previously discussed historical information, as well as the Planning Commission's formal recommendation, and approve, provide a modification of approval, or deny the variance request to reduce the lot standard and setback distances to allow the placements of manufactured home on lots 17 and 125. Also, a special note is staff will generate a formal resolution for adoption at the August 12th, 2024 meeting, City Council meeting that corresponds with the Council's decision made tonight.
Okay. Any questions or comments about what Aaron covered so far? Any thoughts about how to proceed, Mr. Luck?
Mr. Mayor and Council, we have an attorney here representing, I think, the applicant this evening that may want to speak. And we have also in your packet a letter from, we have a letter drafted by this attorney, and we have a response letter drafted by our attorney. And I think that, I think, Mr. Mayor, that you've been clear in the past that we want to work with this business. We want to help them be as successful as possible, but public safety is paramount. And so how we can achieve that is really, where we can try and find some common ground, and if we can get to that point, I think that would be beneficial for everyone. So,
Do you have any prepared statements or anything, or are you just here as an observer? Or?
Yes, Mr. Mayor, may I approach
Please.
the podium?
Yeah, please.
Well, first off, thank you for the opportunity to present to you at the hearing this evening.
Could you,
sure.
could you introduce yourself?
Brian Huntington, I'm an attorney with Larkin Hoffman, and I think you've all seen or been provided my July 3 letter. And I'm going to strive not to unnecessarily repeat what was said there, but in light of the fact that I received correspondence from the city attorney on the 19th, I asked for an opportunity to respond to that tonight. In the July 3 letter, I observed that as conditional use permits are of indefinite duration, so too were their historical analog, the special use permit. We know this property received special use permits in 1970, 1971, and no one has taken the position at any time that there was a violation warranting the termination or rescission of those special use permits. Those special use permits are still alive today, and so it's not accurate to say that this is a non-conforming use. It is a conforming use. Those special use permits are still there. They've never been terminated. And that's very significant.
May I ask you a question?
Yes, sir.
I don't mean to be rude or anything, but I need to ask questions from time to time. Has anyone produced the special use permit that you're referring to?
My understanding is that
Have any of us
investigation has been
ever seen
undertaken
it?
and it has not. Though I would point out under state statute, it is the city that actually does recording, holds the conditional use permit. Now,
Well, see, the reason I ask that is because it's my understanding that it's incumbent upon the property owner to produce it. Is that not true?
I don't think that's true, and I've never encountered a situation previously where a city did not have a copy of a permit that it had issued such as like
odd.
this.
Yeah.
It is an unusual situation in that regard.
Okay, sorry to interrupt you.
The reason why I think it's significant is because for a variance, context matters. And the context of this property is that you have a property that for some 50+ years has had a special use permit to permit the use. I'd like to talk about a comment that was made here tonight and in the July 19th letter, which is what I'll refer to it since that's when I received it, about the landowner's use. To be very clear, under Minnesota law, the landowner's prior knowledge. A landowner's prior knowledge of a nonconformity, which we disagree that there is a nonconformity, but a landowner's prior knowledge cannot be taken into account in acting on a variance. And I'll quote from you, Upper Minnesota Yacht Club versus City of Shorewood, 770 and NW2D 184. Oh, I'm sorry, incorrect quotation. This is Schultz v. Town of Duluth, 2022 Westlaw 433255, page 9. Quote, this court has held that a property owner does not create his or her own plight by purchasing property with knowledge of its nonconforming status. So the city shouldn't be placing weight upon what it believes the landowner knew or should have known. That's not a relevant factor in the variance analysis. There's been a lot of discussion about Minnesota Statute 462.357, subdivision 1A. And again, it's significant in the context of the variance because you should be deciding this based upon the context. And the statement was made in the July 19th letter that statute neither changes nor invalidates nonconforming law. And there's a citation to Croy Holdings versus City of Newport. Well, I read that case. That case does not talk about this section of the statute. That case was about whether a use had superseded the historical use. It wasn't about the specific question that you're being asked to decide tonight, which is, can you enforce statutes subsequent to the adoption of the construction of the park if at the time it was constructed, it conformed with the existing ordinance? In other words, if it met the side lot and the density and all of those types of dimensional requirements, can you enforce or even adopt subsequent ordinances that seek to modify that? And the answer to that is no, you cannot. The statute is very clear and it's very, very specific. This is a very unique statute, particularly regulating these campground uses. And it doesn't look at the landowner. You know, there's been discussion about, was there a continuing use by the landowner? Was there a year plus lapse of time? Well, that's relevant under the non-conforming use section of the statute. That's not relevant to this section of the statute. This section of the statute looks at, was it conforming at the time it was constructed? And if so, city, you may not adopt or enforce standards that seek to alter. Why is that? Well, this case is a great example of why that must be the rule. You've got a campground where there are lots that are developed on either side of the subject lots we're talking about. Those lots have existed for a long time. This campground, as you've seen, there's been many changes to your ordinance, and it's become ever more restrictive over time. You ought not judge a campground from 1970 based upon today's standards. That's not reasonable. You should be looking at what was the context. We didn't create that situation. The current landowner, which just acquired the property a few years ago, we didn't create the situation. That's not a circumstance that we created. We're stuck with that. That's a practical difficulty under the variance criteria.
How much longer do you need?
Just 30 seconds, Mr. Mayor,
Okay.
if you mind. Okay. The reasonableness inquiry, it's very reasonable to approve these campsites when, as you have heard, there is variety because of the fact that this is a campground for 5+ decades in terms of the dimensions. If you look at the letter from the economic development director that was referenced by staff, that letter is referencing a conversation with the fire chief, I believe, who says 15 feet of separation is adequate, and then notes, actually, there's a lot of sites here which are 15 feet or less, and he says that's adequate. So there's no fire safety concern. No one came before the planning commission and voiced any concern about public welfare or safety. There's no basis for such a finding when this lot is very much in compliance with the campground as it exists. And so we're asking for a variance to be approved to memorialize the fact that these lots may be used consistent with the application.
May I ask you a question?
Yes, sir.
Why do you keep referring to a mobile manufactured home park as a campground?
Correct. That's the correct terminology. Manufactured home park. Yes, sir.
Okay.
No other reason.
Okay.
Without any questions, I'll sit down. Thank you.
Mayor, council member, it is as I suspected, and that is that the attorney for Continental Communities has basically indicated that this body has no choice but to grant the variance as a matter of law. No. And you're sitting here in your judicial, quasi-judicial capacity. So I will quickly cut to the chase. Right where I started the letter. As with any zoning application, in this case a variance application, rarely does this body have an absolute obligation to grant, and especially on variance. The standard is practical difficulties. Let's focus in on that adjective, practical. You decide, in your judgment, on behalf of the residents of the city of East Bethel who have elected you, whether it's practical for this applicant to have this variance. And there are facts in support of the applicant. There are facts in support of a denial. And there are facts for you to decide that you may grant the variance with particular conditions. Nothing less, nothing more. Now let me go back to that quasi-judicial, because obviously you're sitting in the capacity as a judge on this local matter. So council does have one thing, right? And that is at times the law does constrain you, right? A lot of times it just provides some guidelines. In other words, if you're bowling, make sure you strike a pin, right? No gutter balls. But you do have that lane. Rarely do you have to hit and have a strike or have to gutter. So what is the lane here? Council basically says that when you have a mobile home park, a city cannot change its zoning with respect to that mobile home park ever. That's what he said in fancy legalese. There's nothing in the statute on 462.357, nor is there any appellate court, whether it be the Minnesota Court of Appeals or Minnesota Supreme Court, with such holding. And I can't guarantee what the courts would ever do, but I feel very, very confident that the courts would never, ever hold such. So let's go and break this apart just a little bit. A special use permit is not a conditional use permit. If they were, we wouldn't have two different terms. Special use permits are still valid as a matter of law. Question is some special use permits run with the property? Some special use permits are very personal. In other words, only the holder can rely upon them. That's their special aspect. Successors in interest may not have the benefit of that special use permit. But you know what? That's a distinction without a difference, because frankly, whether it's a special use permit or conditional use permit and so forth, I think we all agree that based upon the facts here, this mobile home park has been operating fairly consistently with respect to the number of units, the number of lots, and the dimensions of those lots from that time to the present. What changed in 1979, and with all due respect to the council, I've looked at the particulars from 1979 to the present, and frankly, the zoning with respect to those lots have been fairly consistent. But from 1979 to the present, what's also been consistent is those lots now are too small and have been for 45 years. What does the statute says? The statute says, as long as you keep those lots and you continue to use them and so forth, the city has no choice. The owner gets to have mobile homes, that structure size, that structure placement, in perpetuity. That's what the statute says. But the statute also says that you're no longer conforming, so that in perpetuity right and so forth is subject to nonconformity law. So what is it? Let's focus on the variance, because council avoided this one, and that is there's two aspects to this variance. One is an expansion. If we're looking at the expansion, you have the record basically gives you carte blanche. You can deny it, but you can also grant it. And he doesn't want to let you know that as a matter of law. You can deny it because of that expansion. Let's set that apart though. Let's assume that they came in with a mobile home that had the same exact dimensions that was in place in 1978, or the last time we knew of a mobile home of approximately 2008, 2011. But they discontinued it. At which point, it's no longer illegal nonconforming. At the end of the day, council and I have a disagreement as a matter of law. But even then, if you looked at the nuances of it, where we don't disagree, and I'll have a hard time conceding this, so I'll do it for him. I know that's a little bit of hubris on my part. I'm going to go back to where I started. I'm here representing the city and empowering you to make a choice. I'm not here to tell you what your choice should be. That's your job. You can accept the variance without any conditions. You can reject it outright. You can do something in between. Please do not have attorneys representing a single applicant tell you otherwise. As you all know, I'll do that when the time is right. And I try to keep those times to a minimum. Thank you.
Thank you, Eric. Questions, comments?
Aaron, how much longer do we have to act on this?
Without calling a special session by August
22nd.
5th, you'd have to make a decision tonight unless you want to call a special session to make this decision.
Okay.
Or unless the applicant
Is
in
agreeable
writing waives 120 days, but we would need it in writing.
Didn't we
Okay.
already do that?
That was
We verbally agreed to the extension of the 60-day.
So
To
we're
the
at,
120 day.
we're nearing 120 now.
This is correct.
Mr. Mayor, I just highlighted a portion here of a statement from the attorney which indicated that it would be difficult to find a manufacturer home of this size that was originally on there, or any customer interested in a home of that size. I think we validated earlier, researched earlier, that you can buy homes of this size still. And whether a customer is interested in renting a home of that size or living in a home of that size isn't necessarily the, it's not necessarily your responsibility to enable that or not. You had indicated earlier that you want them to be successful. That's independent of whether we can safely place a home in this location of the same size that was removed before. As to whether they can rent that, that's not necessarily your business, our business, or our wheelhouse. I think I understand that people would want a bigger home. More space is always preferable. But when it comes to sight lines, when it comes to close proximity to other homes and fire risk and that sort of thing, I think that has to be taken into account. So.
Other thoughts, comments?
I'm looking at the summary that Aaron supplied for us, and you got your front setbacks, rear setbacks, left side, right side. On lot 17, there are smaller front setbacks. On lot 115 actually is 5 feet, 5'9" on 17. If you look at all the other setbacks and the dimensions on them, there are trailers or mobile homes that have been approved. These are all approved, right, Aaron?
These were all permitted.
So they're not done?
No, these are all placed and permitted.
Right.
Yes.
So then they got COs on them and everything else?
Correct, with
Okay.
the exception of the two that we have the variance
Right.
requests on right now.
My point is that if you look at the setbacks, there are closer ones that have been approved versus what they're saying about 17 and 125. And, in my opinion, if we're gonna issue permits to do this, we're gonna do inspections on all this. 3 or 4, I understand. And then when it comes to the final, CO, and now they have to get a variance. I guess I'm not understanding why that is.
CO being a certificate of occupancy.
Right. Because at that point, I mean, we issued permits on all these. So I'm just looking at this, like I said, there's different setbacks that are closer than what even these new ones are. So, I mean, if it's an issue for fire or whatever, which on Stephanie's letter says 15 feet by the fire chief is fine, most of the setbacks on 17 and 125 meet that. So my concern is, like, if we're gonna issue permits to do all this stuff, we really need to pay attention on these setbacks as well, because now we're forced to do a variance, well, not forced, but asked to, when other ones in the same, similar situation have been approved. So I don't understand why the other ones were approved, and now we're sitting here with two new ones where the setbacks are different.
Thank you, Council Member Smith. My response to you would be that is the reason I provided you the memo for lot 45. It is, to my knowledge, that the building official or the building inspector at that time was questioning the standards and brought it to his supervisor, who went to the city administrator and then went to the fire chief to come back with their conclusion that that would be acceptable. My second point to your question would be that not one city employee, I don't care if they're a building official, a city administrator, a community development director, they're not allowed to change city code by making a decision in the office. That's an administrative decision they don't have the authority to do. These were permitted to be placed over this time by someone who probably should not have had the authority to approve those placements, and this should have been tackled several years ago, but was not.
And I agree with what you're saying there, but the other permits were approved in similar situations, so why are we zeroing these out as an issue when the other ones, I mean, we're less than a year. All these other ones were approved. So I mean, I understand we can't change the ordinance. I understand that. That's not what I'm getting at. I'm talking about the permits that were approved by our building officials, and all the inspections were approved until the end for the certificate of occupancy. And then it's a question saying, well, no, you can't do this. Now, we've already had recently, just on the front East Boulevard, I remember, a situation, same thing, we issued a permit, everything is fine, and then all of a sudden, oh, you can't do that. We can't do that, in my opinion. I mean, if we're gonna issue permits, we gotta know what we're doing. And for residents to have to, I mean, personally, I just say, this is my own personal opinion, I would approve the variance because the way we handled it. And that's my opinion. That's it.
The distinction I think you have in the previous history to today is that you have a different community development director that's in that position that may see the code black and white as
true.
is.
That's true. But
Whereas the other community development director prior to my arrival sought the approval of the city administrator and the fire chief in decision making.
right, but
And
still,
we were not parties to that conversation.
Nor was I, that's why I
They should
sought it.
appear here, if you're a fire chief and you wanna tell the city council, it's fine for mobile homes to be 15 feet apart from a fire code standpoint, you tell us. You don't tell the staff and then everything goes around behind us, and then we're sitting there with a mop 3 years later trying to clean up a mess that we didn't create.
I feel your pain.
Yeah, I hear you. I know you do.
Were all
still,
these other homes conforming or non-conforming when they were issued the permits?
That I can't answer. I do not know whether there was a home on those lots and then it was removed and then there was a permit or not. I would have to go back through some historical data to determine what happened or how that came to place. This was before my position in this office.
I hear what you're saying, Jim. My position on this is real simple, actually, since nobody else is speaking up. Is we want this business to succeed. We've seen change. I've been over there, and at least 2 of the other council members have, maybe more, have been through the Cedarwood Estates, and we see signs of improvement, and that's great. And it looks like it's being well taken care of in places that have been worked on. And there are other parts that are like it used to be and still is, I should say. But we want the business to succeed, and we want it to succeed with a respect for our zoning ordinances. And so I cannot, in good conscience, approve this because of the way it was done. I don't think it should have been done that way, and I don't think it creates a precedent that we have to follow. So that's where I'm coming from. And I think if the city and continental communities can work together and pursue a mutually acceptable and beneficial path, great. That'd be our desire. But the way this has been handled in the recent past, just not the way it should have been handled. That's my opinion. Anybody else have any comments before we call a question and make a decision?
Well, I would have an issue with expanding a nonconformity that it specifically says we
Yeah.
cannot do that.
Yeah. I agree.
Are we gonna have issues with other lots?
Every lot from here on out, we most likely will have a question unless, which I have permitted, an equal replacement of footprint. If it's a nonconformity,
And if it
that
hasn't been
that
empty
has
for
not
more
been
than a year.
vacated for more than a year, I have approved the equal footprint replacement.
And that would be
That is a
appropriate.
continuation of a nonconformity, their legal right to continue by replacing a equal footprint.
Okay, do we have a motion?
Oh, I would just say that, not necessary to this variance, but, no matter how this ends up, that it may be a good idea for continental communities to meet with the city and figure out essentially how to replat
Yeah.
everything so that it would fit and have, clear expectations of setbacks, trailer sizes, et cetera, in the future, so that we don't have the situation again.
Yeah.
So,
Anybody want to make a motion?
I'd make a motion to deny the variance.
We have a motion. Do we have a second? Hearing none, I'll second it. Come on, guys. What are you thinking? What are you thinking? I'm picking your brains here. What do you
I
think?
already told you my opinion.
Yeah. What do you think?
This is a tough one. I mean, I don't like sitting on telling a business something when they've been established and been working at the same time. I totally understand where a planning commission is coming from, saying that we have to abide by certain things. There's a lot of smoke around this one. I don't think we handled it exactly properly, but I don't think we should punish a business. At the same time, I also think a business of this caliber should know exactly what it's doing. When
Yeah,
you're
they have
putting-
31 of these mobile home parks is what their
Which is-
manager said.
Which is what I'm getting at. I mean,
Yeah.
I think.
Been
you
in
should-
business since 1997, I believe.
Right.
Well, I don't know what, it really makes a difference whether or not, if it's these two make it and then no more, I mean, have it be known that, no, there won't be any more variances.
At the end of the day, it's 2 mobile homes. And they can be sold and other ones can be bought that are the right size or whatever, you know. It's not life and death.
No, but I don't wanna sit here 31 more times discussing the same thing.
I agree, that's why I think the city, I think exactly what was said is the city and Continental Communities, need to sit down and come up with a plan that makes sense for both parties.
Yeah, if we can figure out a plan that may change some stuff to allow some
Yeah.
bigger stuff.
Kinda like Brock Auto and the neighbor.
Yeah. Yeah,
But not to say that we can't work things out in the future, but at this juncture,
this specific moment, yeah,
without having a special meeting,
yeah,
we need to make a decision.
yeah. Because I don't want to set some precedent that is going to be used like a club on us in the future.
Right.
And it's a precedent that not only would affect this trailer park, but we do have Greystone in the north that
Yep.
if you approve this for them, there could be precedent that says, well, we need our trailers approved too.
Yeah.
Is that true, Eric? From a precedent standpoint?
Oh, that's, generally, you cannot use the grant of one variance to another entity or another person and say, basically, I get that too. This one here is a little dicey because if we're dealing with Continental Homes, well, they're the same applicant within the same particular area. If you're looking at, and there are very few mobile homes, right? So things start to get very close. I think I would certainly be arguing on behalf of the city that you can't, but I will also admit that an applicant would have a stronger argument when you have, you know, very close like type of identical situations. If I come back to the motion to deny, what I'm hearing somewhat is maybe allowing Continental Homes to essentially put a mobile home that is of what has been historically known as far as the dimensions. If that's the case, you can go ahead and grant this variance subject to that condition that the mobile home has to be of the same dimensions as the last known mobile home as documented within the record. That would be a variance grant, not the application that they did, but you're granting it with your imposed conditions. I just throw that out there. I'm not. Oh. I think we'll wait until that's turned off.
Would anybody be open to having that amendment to the motion to deny? Essentially, a motion to deny unless the mobile home is the same dimensions.
I would
Let's
just,
ask the question, are those 2 spots, are you replacing mobile homes that the lots haven't been vacant more than a year?
Both Lot 17 and Lot 125 have been vacant since 2008.
Yeah. There you go. There you go. So that's expired, actually. Long
More than 1
expired.
year.
Long
The
expired.
nonconformity, more than 1 year.
Yeah, I just don't want to set this precedent. I really don't. What I want to do, and it's just one person, but I think if we deny and then we sit down and discuss it and move forward is a logical way to approach this to me. I think otherwise we're just kind of muddying it up because we don't want to just take the proper steps.
Yeah, but the whole point is, we issued the permits. We knew the size that we gave them permission to put there. That's not their
And it was
fault.
based on information that was not properly communicated and vetted by the city council at the time. Mark Descharme is retired now, and he's down in
I ain't
Arizona.
talking about him, I'm talking
Well, he's the
about
one who said
permits
there
that
were
issued.
plenty of,
I know,
the
but if
15
you look at
feet.
the summary, we're in there easy. I'm just saying the permits
What
that
does
were
that
issued.
mean? What do you mean we're in there easy?
No, I mean, the dimensions, look at the rear setbacks, the front setbacks, left and right. I mean, there's trailers that were.
But they have nothing to do with what the setbacks are supposed to be. If you look at the
They're
zoning.
right here in black and white. These trailers have been approved, and these other two.
But
now,
that
the new
doesn't
ones are
change what
not.
the setbacks are supposed to be. They could make a lot of mistakes, and that doesn't bind you to
But look at your
keep
numbers.
making them.
Look at the numbers, they're right here. I mean, some are closer than what these new ones are even, the setback.
Yeah.
So, I mean, like I said, we can't issue permits if we don't know the size it's going at. And we did.
Did you catch that the lots in question have been vacated for a
I
long
understand
time?
that, but we still approved in a permit. Why? We should have knew that.
Yeah,
And that didn't
I
happen.
just disagree, that's okay.
Right.
We can disagree, it's no big deal. Anyway, so I believe we have a motion made and seconded.
Could you repeat the motion
Motion to deny the variance
with nothing else attached?
with nothing else attached at this point.
Brian wanted to amend it, that the
I-
trailers would have to be the same size as was there.
Yeah, I'd be open to amendment. But it's the expansion of a nonconformity. It explicitly states that we cannot do that.
How far off are these trailers from being?
Let's look at these numbers.
Oh, I would have to pull up my previous report that was provided to you to determine exactly. Actually, I think Attorney Larson in his memo outlined what they were, I believe.
No,
No?
I
did not?
I did not create that third column.
Got it.
Oh,
However,
well,
I think.
oh, wait a minute, I apologize.
You did, I
I did, what I did, the third column I did not create was what the, yeah,
1979 and later.
right, right, so
setbacks.
I apologize. What I created was what they were in 1979. The third column I did not create was then looking and trying to calculate now how they would be even further reduced. So the actual is based upon the last known 2008 mobile homes. So the required front setback, as an example, is 30 feet. Back in 2008, it was 10 feet. Rear yard, and you can just go through it, you can read it yourself.
The question then, Councilman Miller, is since these lots were vacated in 2008, we'd have to look back and see what was set on there in 2008 and how that was close to the existing standard at the time. So for me to answer that question, I'd have to pull up some historical data to even determine.
But Mr. Berg, I took off what you had calculated as
Okay.
2008.
Okay,
Okay, so that's what this is.
Got
The third column I don't have is, and I did not do, was taking a look at the expanded mobile homes and trying to establish how those particular non-conforming setbacks and so forth were even further expanded as far as, like the front yard setback.
so the placements today of the homes that are on 17 and 125 are in the chart that I provided you? What is out there right now is on that chart.
Can you bring that chart up?
Do you want to switch to mine? I've got it right here. So the yellow highlighted columns are rows, excuse me, 4 columns, rows, are the existing placements for the 2 in question. So the front yard setback on lot 17 is 5'9". The rear yard setback is 21 feet. The left side placement is 27 feet, and this is from the neighboring home, not the lot line. I can't determine where the lot lines are without a survey. And then the right side placement from the neighboring home on the right side is 21 feet. On lot 125, it is 6.5 feet from the I believe it's the curb face, where the sidewalk meets the street. It's 14.5 feet from the rear lot line. It is 30 feet from the left side and 29 feet from the right side. And lot 125 is a corner lot, so there is no trailer on, there's no home on, I believe, the left side. But it is 30 feet, which meets our existing standard of a side yard placement on a corner lot. That dimension does meet it. The rest of the dimensions do not meet the standard, from my recollection.
That's a substantial diminishment as far as even further on lot 17, lot 125. It's different, but it's roughly the same as of 2008.
So then at the bottom of this chart, you can see I took all of the ones that were permitted, that Councilmember Smith was questioning, and I averaged the distances that those are from each one of those setback distances. So the average setback from the front yard for all of them is 15 foot 6 inches. Whereas lot 17 is only 5'9", and lot 125 is only 6'5". The average of all those placements is 15 foot 6. The rear yard setback on those all averaged is 19 feet. However, on lot 17, they have a 21 foot, and on lot 125, it's 14.5 feet, so that is short of the average. Left side placement on the average is 25.5 feet. In this case, lot 17 is 27 feet from the neighboring home. And again, this is deceptive on 125 because it's a corner lot and there is no home to the left of it, but it does meet the 30-foot setback. The average distance from the right side or the home to the right on all of those that were permitted is 22'9". And in lot 17, it's only 21 feet. And on lot 125, it is 29 feet. So you can see how those averages play out with the current placements that are out there for the variances that they're requesting.
Okay, so we have a motion and a second to deny the variance request, and we have, again, I was just speaking as one person about if you came back with mobile homes of the same size as the ones that were previously there, even though nothing has been there for a long time.
You would need a variance.
So, is there any reason we don't
It's
just
still a non-conforming.
vote? Yeah. Think of any reason for us not to have a vote on the original motion?
The original is just to deny?
Yeah, and then hopefully have a conversation with Continental and try to work moving forward on conforming with our ordinances the way they are. And we're not bound to continue what appear to me anyway to be mistakes in the past.
Are we ever gonna get an official survey of this site?
That is certainly up to the city. We can make that request. I would encourage that if we are going to continue a conversation about future placements, expansions, those kind of questions, that we require a survey.
That might be a condition that we put on if you want to come back with another variance request. We would like to see an actual survey, proper survey of the property or something.
There is the potential I need to explore. We require any single-family home construction project within the city of East Bethel to provide a certificate of survey. We do not do that in a manufactured home community. We could require a certificate of survey for every lot, for every placement. And some of these issues that showed up may have been recognized on the front end, and we may have said no.
Well, What do you think of that, Eric? Just having a stipulation that future variance requests should be accompanied with a proper survey of the property.
I think that's an excellent
Just a
idea.
thought, just a thought, that's all.
You can certainly embed that in any motion here. It's not directly germane to the application or this particular
right.
2 lots, but it certainly sends a powerful message.
It could just be a request aside from the
right.
actual.
We could also just make it a procedural requirement for an application for placement or the construction of a new single-family home, and that just be how the city handles it, and that would then apply to every single-family home across the city, not just.
Yeah. Well, we have a motion made and seconded in front of us that says to deny this variance request as it stands. All those in favor, say aye.
Aye.
Opposed?
No.
Abstain? So what is it, 4 to 1? All right.
Mayor, council members, if I may, Mayor.
Yeah, please.
One thing that this particular variance application, and I put in my letter to me highlighted, is, and also what has been discussed, is there are a number of lots out here, 150 or thereabouts, and there have been a number of applications made over the years, and therefore the decision made today doesn't necessarily mean that this issue is not done, right? And I just want to underscore, as I put in my letter, that I think this is a good opportunity, and I'm hoping that the leaders and the principals of Continental Community and city staff and so forth can sit down and start thinking about basically what makes sense for the whole Cedar Estates, but also Continental Communities also owns some adjacent properties as well, that I presume that they are also looking at, okay, what is going to be the future use and what makes sense for them. And it does seem to me that there's an opportunity here, rather than to essentially be in a standoff where someone absolutely wins and someone absolutely loses, an opportunity for actually a win-win. So that things can proceed in a way that works for the city and also works for Continental Communities in a clear fashion and an efficient fashion. And I'm hoping that that will occur.
Yeah, we hope so too.
I would echo all of that, and I welcome any conversation. Like you said, we want to be able to work with them, we want them to be successful. If we can do that within our roles and within the rules that we have, then I am absolutely open towards that.
Yep.
I
think we
would
all
like to have that conversation with them, and if we can get this whole thing solved so that they never have to come forward with the variance again, that would be my objective.
Yeah, just put together a game plan together. Okay, the next item on the agenda is variance request for 23558 Ulysses Street Northeast. Dan Graff.
Thank you, Mr. Mayor, and members of the council. As you know, this is coming back to you, but Everything Outdoors LLC, on behalf of Dan Graff, is requesting a variance to reduce the shoreland overlay setback standard for the placement of an in-ground pool. This property is located in the R2 Single Family and Townhome Residential Zoning District in the West Side Estate Subdivision and in the Coopers Lake Shoreland Overlay. Application information along with the Planning Commission's recommendation was presented to the City Council at the July 8th, 2024 regular meeting. At the conclusion of discussion, the City Council requested additional measurements and placement scenarios from the applicant. On July 16th, 2024, the city received 3 separate site plan options with different depths of encroachment ranging from 25.7 feet to 18.7 feet or 14.5 feet into the required shoreland overlay setback of 150 feet. A consideration of a variance requires the consideration of the 3-factor test for practical difficulty. The first factor is a test of reasonableness, which means that the landowner would likely use the property in a practical way but cannot do so under the rules of the ordinance. In this case, a swimming pool is identified as an allowable accessory use in an R2 zoning district. Also, the variance request to place an in-ground pool in a shoreland overlay setback may not be reasonable. The second factor is that the landowner's problem is due to circumstances unique to the property and not caused by the landowner himself. The uniqueness generally relates to physical characteristics of the particular piece of property, that is, to the land, and not the personal characteristics or preferences of the landowner. In this case, the property is located in the Coopers Lake Shoreland Overlay with a specific setback requirement, and the primary residence was constructed within 10 feet of said setback. The primary residence was constructed over 475 feet from the front lot line, 17 feet from the north property line, and 23 feet from the south property line. This placement limits the buildable area in the side and rear yard for any accessory construction. There are also terraced elevations through the property, both front and rear yard. In addition, the subsurface sewage treatment system and well are located in the front of the house. The third factor is that the variance would not alter the essential character of the neighborhood. This factor is used to consider whether the resulting structure would be out of scale, out of place, or otherwise inconsistent with the surroundings. In this case, the proposed location of the in-ground pool is in the rear yard and would not be visible from the city's right-of-way. The primary residence, as I said, was constructed over 475 feet from the front lot line. Standing tree growth along both property lines screen the rear yard from its neighboring properties. The degree of the requested variance is a departure from the scheme of the city's land use controls. At the June 25th, 2024 Planning Commission meeting, a public hearing was held at which there was no public comment. After a review of the application material and hearing from the applicant, the Planning Commission by a 5-0 vote recommended denial of the variance request. Council should review the request, consider the Planning Commission's formal recommendation in addition to the additional information provided by the applicant, and approve or deny the variance request to the standard shoreland overlay setback of 150 feet for the placement of an in-ground pool at 2355 Ulysses Street Northeast as presented in Resolution 2024-45A or 2024-45B. I did receive additional information from the homeowner, Mr. Graff, today, late in the afternoon. That is provided in the red folder to you for your review. I also have the 3 separate potential placements for conversation. Should you want to choose to see the degree at which these different placements would encroach into the setback.
For information purposes, I move the resolution 2024-45 granting a variance for the reduction of shoreland overlay district setback from 150 to, there's no number in there.
It is blank because you have 3 options in front of you. We need
Right.
you to choose one of the 3 options.
Right now, I'm just gonna open up for discussion,
Okay.
if I get a second.
So your motion is to open up for discussion?
Yes.
Okay, I'll second. So, first off, I'd like to thank Mr. Graff for having patience with us and trying to work with us. I think the original submission was 64 feet into the 150-foot overlay, and I think they did a very good job of reducing it down to 14.5 feet or 18.7. Either of those I could live with.
Well, judging by the packet that was submitted today, it sure gives a lot more answers to the questions that came before the council before. Pictures and drawings definitely put things more in perspective. Cause it's kinda hard to look when you're just looking at nothing there. This,
I do understand this question, but still, I'm getting too old to do it. Anyway, it doesn't like these photographs. These, we put down a tarp, we actually put down a tarp, where it would be.
oh, the size of the pool?
Yeah, it's the size where the pool would be, and it actually shows.
Oh, here.
Oh, there's
Pass them
five
down.
copies there.
I believe these are for us to look at.
Why is this stuff just showing up at the last minute? Why is that?
That's what the applicant decided to provide you tonight.
How
I
long
got-
do we have to make a decision
got-
on this? 'Cause we've been at this for 3.5 hours since we began this afternoon. And, you know, we need time to digest all this information. It just dropped on us.
So this tarp that's down here, that's the correct representation.
Did anybody else have this before this meeting?
No.
No, you were just handed that. I've not seen that myself. 2 o'clock this afternoon.
Yeah, we started meeting at 5 o'clock in a work meeting. So we've been here for a while.
So I believe Mr. Berg is looking for the application
I
date.
am.
And once he has that, we'll figure out the deadline.
So only, instead of trying to sort through this, my recollection at our last meeting was that you would look at alternative places to put it, and on page, whatever it is, it says possible other locations for the pool. What's the upshot of it, so I don't have to read it necessarily? So what's with the floating deck? What is that?
The floating deck is that if we get into the whatever it wants to get into.
To the graphs, if
To
both of
reduce-
you could come up
reduce
here
the
to the
depth
record.
to the lake? Yeah, sorry about that. But that's a means of reducing the amount it sticks into the, okay.
Dan Graf. Basically, it's, the floating deck takes the place of concrete around the pool. So if you're gonna consider concrete as a permanent structure, which it really isn't.
So this is the apron or whatever you call it around the pool? Okay.
To the high water mark, so. Under the measurements in your portfolio there, you have 3 different options that reduce the encroachment to the high water mark.
Oh, so the floating deck sits above the, basically on the ground, so it's not a permanent
Correct.
structure?
Actually, even the fence that you have at one is also a removable fence.
Oh, okay.
It's not permanent.
That's pretty clever.
Yeah.
Yeah. Thanks for the supportive information, detailed information.
My wife worked real hard on that, not me.
Looks like it.
Well,
Yeah.
it kind
We
of,
can tell.
kind of puts the stuff that we talked about before into perspective.
Mhm.
So, Mr. Mayor, if Councilmember Mundo would like to offer an amendment to the motion for the distance, to fill in the distance?
Oh, the motion was just for discussion.
Right, and if you want to offer an amendment for 14.5 feet or 18.5 or whatever the amount is, then if you get a second to pass that
Kind of like a
amendment.
stipulation,
Right.
but, yeah.
Oh, my understanding was the motion was just for discussion. It had nothing to do with,
No, he read off the resolution granting a variance for the reduction of the shoreland overlay setback from 150 feet to
Okay.
blank.
Okay, I get what
And
you're saying.
you
I thought,
indicated-
I
you-
thut it was just for discussion, not,
Well, he
but
wanted, yeah.
anyways, I'll, for discussion, I'll put the dimension of 18.7 in there.
Which is it, 14.5 or 18.7? What,
Yeah,
again, I'm not wading through all that, just to.
25.7, 18.7, or 14.7.
You're looking at the 131, I believe, that's the middle option in distance and encroachment.
Yep.
So the setback would be reduced from 150 feet to 131 feet,
Thank you.
3'5", under that middle option.
Sounds fine to me.
Yeah, I'd second that.
Sounds good to me.
so I assume that, if they chose then to be more restrictive with the 14.5, they could still do that? Okay,
They would be permitted up to
Yep.
a reduction
Okay.
to 131.
So Mayor, there would be a vote on the amendment and then a vote on the final.
Okay, all in favor of adding the amendment to the motion to stipulate in the opening line of the resolution 2024-45, a resolution, excuse me, I'm on the wrong one.
Right up here.
You were right, 20, 24, 45.
Approving, granting a variance for the reduction of the shoreland overlay setback from 150 feet to 131.7 or .3, 131.3. Is that right?
however, it
100
figures out to
Yep,
18.7.
131 feet, 3.5 inches.
Okay.
Yeah.
All right, that's what has been motioned, or that's the amendment, and so we'll have the vote on the amendment first. All in favor, say aye.
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 Opposed? None heard. Then back to the motion as amended for resolution 2024, approving it, granting the variance. All those in favor say aye.
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 Opposed?
It's
None heard.
2024-45.
That's what I said, isn't it?
No, you forgot the 45
2024-45?
part.
What?
Forgot the 45 part.
I did? Oh,
Yeah.
thank you.
Sorry.
No. Again, thank you to the Grass for working with us and being
Yeah,
patient with
thank
us. And I'm glad we could come to an agreement.
It's all about striking balances. That's what the whole job comes down to.
I hope the grandkids enjoy it.
Yeah. All righty. Do we have nothing else in department reports? Any staff reports?
Mr. Mayor, I do have some here. I wanted to read into the record some of the responses we got from our deputies here this weekend as it related to Base Ribbon Festival. We got what appears to be about 5 calls maximum, and there was one confirmed noise violation on Friday, which when Mr. Jordan was notified of that, he fixed it immediately. It
Good.
says, let me just read this into the record. This is copied from an email. This is from Derek Peters, the Nook County deputy. This is copied from an email I received from the deputies working on Friday. Decibel readings are below. Based on the L10 standard set by Minnesota Pollution Control, we only had one confirmed noise violation on Friday, which was remedied by telling Mr. Jordan to turn it down. They received a call from 1927 209th Avenue Northeast. They received a call from 1828 209th Court Northeast. And they received a call from 20305 Highway 65 Northeast. They took the following decibel readings of 49 to 53 from 209th and Jenkins. They took the decibel reading of 50 to 53.7 decibels from 1828 209th Court Northeast, and decibel reading 58 to 62 decibels from 20305 Highway 65. Says I went with the L10 standard for residential areas, so 55 decibels would be over for nighttime. After I'd had the reading of 58 to 62 at the 20305 Highway 65, I went to Blue Ribbon and spoke to Ray Jordan. He was very quick to lower the music, and after he did, we did not receive any additional complaints. This is the second email I received about Saturday night, which is copied below, and that came from 19926 Buchanan Street Northeast. 2 calls came in from that location. Both calls were the same caller, and on the second call, he was not cooperative with the dispatch and hung up on them. He also told dispatch on a second call that he had called an hour prior when it was only 19 minutes. Mason was tied up on a DWI, and I was on a medical at Blue Ribbon, so we were not able to get a decibel reading. The music was turned off around approximately midnight. Other than noise, there was only 1 call from the event while I was working, which was a medical, and he hopes that this was helpful for council. I know council got a couple calls on this. A couple emails were sent to me on it, so I asked them to chronicle kind of what was called in and what the reports were so that we can read that into the record as it relates to any future permits for this festival.
Yeah, I appreciate that being read into the record, and there is a qualifying item here, and that is we got complaints about the noise level, but also about the content.
Yes.
Extreme profanity, which does not need to be broadcast in everybody's home. So it's the content too. It's not just the volume levels and the hours, the time of day. It's what you're broadcasting out, and so that's going to have to be an issue we address if he wants to do this next year. Okay. But I was happy to see that the owner was responsive, and that there are always going to be some complaints, but that it's documented on the decibel level and all that. I think that's the way to do these things. If we're going to strike that balance,
Yeah, the profanity was the biggest complaint that I got.
Yeah, that's pretty tiresome pretty quick.
The second item I'd like to comment on here is we had a virus that kind of shut down a lot of city laptops. CrowdStrike antivirus sent out an update that had a virus. And as you know, we contract with Metro INET, and I think our annual budget amount, don't quote me on this, around $80,000, maybe something like that. They have a whole team that was dispatched on trying to fix this problem. We could hire an IT professional, probably for more than that, and they would have probably struggled to
That was over 500 computers.
Right, get their arms around this on a timely basis. So they did a wonderful job in getting the systems back online.
Yep.
There were airport delays. You probably caught that on the news. I can't imagine what CrowdStrike is going through.
Well, I watched their stock fall like a rock rolling off a table. Fortunately, I don't have any of it.
I wanted to comment on Booster Days Festival, and I just want to thank everyone involved in this. I know Carrie and Des were working overtime on this. I want to thank Nate and his staff. They did a phenomenal job, and the sheriff and the fire department as well for being there. It's always good to have them there for the public. And I think the weather was exceptional, but there were some people that talked about not having a parade, and I think the parade might have drawn more people. I was speaking to an individual that says, in our community, the Lions generally coordinate the parade. So I took that nugget of information and thought I would bring it here, and perhaps the Lions might want to participate in coordinating that next year. Something we can work towards that might help to build more public attending that.
Yeah.
And that might have actually spurred some more volunteers, because some people that I talked to said, well, we just didn't have the volunteers put it together, and they said, well, we're not that busy. I said, well, I'll get you the information then. It's only $1 million a month.
Right.
So.
I will also report that tomorrow is the public accuracy test for the voting machines. tomorrow at 9 a.m., and that is open to the public, so the public can come and view that accuracy test if they have any concerns as to election integrity or anything of that nature. I would definitely encourage folks to come and be witness to that. As you know, the county's been in the process of searching for a county administrator, and tomorrow there is a vote on that administrator position. This is public information, and some of you may have heard that the finalist was the city administrator for Andover, Jim Dickinson. And Jim Dickinson is a former county employee, a real sharp guy. I like him a lot. And I think the word is there's no opposition to this, so the vote will tell tomorrow, obviously, but I think if he gets the head nod on that, I think that'll be a fine choice for the county. He's very easy to work with, so.
Good.
I think we'll continue having a positive relationship with the county, with him in place. And then the final thing I want to say is that, I don't know if you noticed the new lights.
I did.
Brighter, okay.
Thank you.
Two times the lumens of what was there prior, so hopefully that helps light
It
things up
does,
here
it
to
does
read.
help. Thank you.
So, that got done. But at any rate, I think that concludes my report, unless there are questions.
I'd like to mention something before we adjourn tonight, that the Booster Club, their volunteers, they did one heck of a job. All through the year, they've been stressed out, they've been worried about putting this together, and they pulled off what I think is a really nice event. They're there the day before, they're there that morning when it opens, they were there when it closed, sunbird and all. And special thanks to City. They had that park, they had everything ready to go, the fields look beautiful. Stephanie Dorn does a great job. She's a fun person to work with. If you want to volunteer to help make it even bigger and better, get a hold of her, she's great. Pack 387, local Cub Scouts, thank you for helping
Cleaning
to
up.
pick up the park. It goes a long way around here, so thank you. Other than that, that's all I want to say about that.
Thanks, Tim. Any other council reports?
I'll just echo all that. Booster Day Committee puts on a
Yeah.
heck of a show, and
A lot of work.
it's really great to, one, keep tradition going that's been going on for so long, and to do a good job of it. It brings the community together. And so huge thanks to Stephanie, all the volunteers.
Including Mr. Miller here.
Mr. Miller.
I am just a liaison for them. I watch them do a great job.
Yeah, and all the city
Humble
workers
guy, you.
that were involved with it. It's always a great time.
And we will return the parade at some point here in the near
Hopefully,
future.
fingers crossed for next year.
Yeah.
I want to say also thanks to everybody, all the volunteers, and Freezy Pops were good too. That worked well too. Even people wanted to take more home, but that was good, and everybody did a fantastic job.
Yeah.
And I'll tell you what, I noticed there was a lot of people my age or older that were out there volunteering. And
That old?
Oh, yeah, and it was, they were working
He's
their
younger than
tails
me,
off, I'll
thanks.
tell you, and it was hot. But thank you. How old?
I just said, he's younger than me. Thanks a lot.
That's right.
Yeah, by 4 or 5 months.
Move to adjourn.
Second?
We have a motion made to adjourn and a second. All in favor, say aye.
Aye.
Opposed? None heard.
We got HRA.
Oh, that's right. Last time I took off.
Another meeting?
Yeah.
Yeah? Oh, yeah.
Number 3.
Sure.
Yeah, who's the,
Jim is the chairman of the HRA.
Okay, I'll call
Do
the,
you need me to send the gavel down?
no,
there?
I don't need that. I think it's probably cracked
oh,
anyways.
I think you ought to make it professional. Yeah, it might be cracked.
Yeah.
What gives you that idea?
I'll call the Housing and Redevelopment Authority dated July 22nd, 24, call the meeting to order.
Make a
And
motion to adopt agenda.
Second.
We have a first and a second to adopt agenda. Any discussion? Proceed to vote. All in favor, say aye.
Aye.
Opposed?
Nay.
No. Nothing heard. 3, the
Move to-
approval of the minutes from April 22nd, 24.
I approve the minutes.
Second.
Any discussion? All in favor, say aye.
Aye.
I move to adjourn.
Approve.
Second.
Before we approve or adjourn, I'd like to say,
Oh, yeah.
I'm trying to figure out, what are we doing with this, Matt? What is this? Because I mean, it took us, what, 3 minutes or so to do this? What's involved for this? I mean, what do we do? I don't understand it. I just don't. I mean, what is it?
Yeah, Mr. Chairman and trustees, I believe the word is. It's essentially, we had meeting minutes that just needed approval for the public to be able to view that at some point. We did not have any business for the HRA to conduct here, so we were just getting it on the agenda to approve the minutes and be done quickly.
So then as far as like the HRA though, what would we do? I mean, is there something that we can do as a group for the residents or something? You know what I mean? Because I don't know.
I can take it if you want.
Right, so, yeah, so the Housing and Redevelopment Authority has the statutory right to kind of look at blighted property in the community if they want. If you have resources to purchase that, you can either bond for it, if you have, cash on hand, to purchase that and then kind of maybe raise the property, clean it up, and make it for sale. That's generally what a Housing and Redevelopment Authority does. I'll give you an example. In Ramsey, there was I don't know if many of you recall this, but there was a green building on Highway 10 with 3 large X's on it.
Yeah.
And Ramsey was becoming known for that. HRA dollars were used to purchase that building and level it. Now there's a brand new, it's called Blue Line Collision. They're they help put cars back together, what is the word I'm looking for?
Restoration?
Thank you. Beautiful new building. So in that particular case, the city stepped in, bought what was a blighted property, removed it, sold it, or gave it, or whatever the arrangement was, to the new development that came in. Your tax base now is improved beyond obviously what that little green building was bringing in. So, of course, from a entrance to the city kind of impression of Ramsey, that went right through the roof, obviously, because you didn't have that eyesore. So there may be properties in the city of East Bethel that might fall in that category, that the city might want to, at an arm's length transaction, purchase from a current owner and make available for development. When you own a land, you can kind of determine what you want there. It's not anyone that comes, it's who you want to come type of thing and make available to them. That can be, we approve some things on TIF, that can be a TIF type of arrangement if there's a TIF set up in that area. There's different funding mechanisms for that, but.
Do you want to touch on the ambiguous state statute that is putting sales tax into communities to be able to develop housing? And what the HRA's function would be for that sales tax money?
Right, there is a quarter-cent sales tax that was passed at last year, I believe it was, where every single metro community is putting a quarter-cent sales tax into a pot. And then if you have projects that apply, you can get a certain percentage of that back through the county if you have an HRA, if you're part of the county HRA. Now, East Bethel is not part of the county HRA, but the legislature is looking at accommodating those communities that aren't part of county HRA. So that's something potentially coming in the future here, we'll see. But yeah, the HRA generally does not have a lot of money in it. And so there hasn't been an active HRA in the sense that you're pursuing these type of properties. A property might cost $500,000 or whatever the case is. And so that would be a policy decision of this board. Do you want to take more of an active role with an HRA to start identifying blighted properties and reposition them for development?
Well, that's a topic for another day,
or contribute to senior housing type of
for
apartment
history.
complexes.
Well, just reading between the lines, what Jim was saying is we have no goals, stated goals. And the purpose of the HRA was not to fund staff salaries. That's not why it was created. Right. And I mentioned in January, I believe, that we didn't have any goals and we needed to go. So what I would like to do is, as part of a work meeting, coming up, like not waiting till the next HRA meeting at the end of a long regular, city council meeting, but and the next work meeting is let's brainstorm some ideas, goals for the HRA. I've heard from one person that having lights that shine up on the East Bethel water tower would be a nice, visual thing for the city, to have nice signs where you enter the city instead of just a scrawny little, East Bethel, something more elaborate like beautiful East Bethel or whatever. Just, but some brainstorming, for ideas to increase the ambiance of East Bethel.
Well, the lights on the water tower, that was gonna be a reality at one point.
Mm-hmm.
Just like our sign that they fought so hard not to let us put up, the previous councils, when we put the sign up on 22 and 65. Yeah, but the lights on the water tower, that was something we wanted. I mean, why have it if you can't see it?
But, yeah, well, it's just like, you're not gonna accomplish anything if you have no goals, period. So it just seems time to me to, actually try to figure out some priorities for HRA.
I believe the last use of HRA funds was to help create the road that the now senior living facility is on. And I believe that
Tyler Street or something like that?
Yes. On the,
Taylor Street?
on the
Taylor?
on the
Oh, I
west
thought it
side of
was Tyler.
65.
We have them both.
And
Taylor.
I think we had $700 and some thousand in there at that point, and that was the only reason that we could do that.
Yeah.
So.
There's
It-
more behind
it-
that too.
But if you identify goals,
Yep.
getting
Yep.
money is less difficult if you have a clear vision of what you wanna do.
Yeah, but just to say that if we have money in there, we need to spend it,
Oh, no, not,
Yeah.
No, not at
No,
all.
it's not,
So-
that's not the way to go about it, to have goals first.
It's gotta be more than an eggshell
So-
game. Where's the
Anyway.
pea?
So is there any more discussion on this?
no.
Okay, we have an adjourned motion, yes?
I make a motion
Second?
to
No,
adjourn.
we already did that.
Oh,
What are you
okay.
in a hurry here,
Second?
or-
All in favor?
Aye.
Aye.